A very good morning to all of you. Justice Sanjay Kishan Kaul, Chief Guest of this function, Judge Supreme Court of India. Justice A.K. Sikri, Chairman, ILA Global Advisory Board. Mr. Scott Atkins, President, Insol International. Mr. Amitabh Khan, former CEO, Niti Aayog. Sri Sumant Batra, the force behind the whole function. Founder, Insolvency Law Academy. Members of NCLAT, Sri Narhari and Sri Shah Merla. Mr. Sahu, distinguished guests, insolvency lawyers and professionals, ladies and gentlemen. As we gather here today to mark this occasion and discuss the theme of Emerging Global Insolvency Horizon, Indian Footprint and Front View, I am reminded of the important role that India has played and continues to play in shaping the global conversation on insolvency and bankruptcy. The Insolvency and Bankruptcy Code 2016, which was enacted with the goal of promoting entrepreneurship, improving the case of doing business, and ensuring timely resolution of insolvency, has been widely praised for its effectiveness. It has provided a framework for resolving insolvency in a time-bound manner. The code has not only provided an efficient mechanism for resolving insolvency, but also has provided a much-needed framework for dealing with cross-border insolvency. However, as with a new law, there have been challenges, and we must continue to work towards improving the system. As chairperson of the NCLAT, I am committed to fostering a culture of trust among all stakeholders, including the Committee of Creditors, insolvency professional entities, and the judiciary. We must work together to ensure that the rights and interests of all parties are protected, while also ensuring that process is fair, transparent, and efficient. The various subtopics covered in this conference are highly pertinent, and the discourse surrounding them is a crucial step in shaping the future. These sub-themes are not only timely, but also essential for understanding and addressing the current challenges facing our society. The discussion of these sub-themes is vital for developing solutions and strategies for moving forward. It is worth this dialogue that we can gain a deeper understanding of the issues at hand and work towards creating a better future for all. The theme of insolvency professional entity as insolvency profession, exploring opportunities while managing risk, is of great significance, as it highlights the need to balance the potential opportunities that come with the growth of insolvency profession with the need to manage the associated risks. The insolvency professional entities play a vital role in the resolution process, and it is important to ensure that they are well equipped to handle the responsibility that comes with it. The opportunities in the field are numerous, but so are the risks. It is vital that we explore ways to exploit these opportunities while managing the risk effectively. The Insolvency and Bankruptcy Code has provided an opportunity for the growth of an indigenous insolvency profession in India. This profession is expected to play a vital role in the successful implementation of the code. The insolvency professionals should be individuals who possess the necessary qualifications, experience to discharge their functions effectively. They should also be regulated by a professional body to ensure that they adhere to the highest standards of ethics and professionalism. One of the key areas that we must focus on is the culture of trust among all stakeholders, including the committees of creditors, insolvency professional entities, and the judiciary. The IBC is based on the principle of maximization of the value of the assets, but this must be done in a fair and transparent manner, with all parties' rights and interests protected. This is where the role of NCLAT comes in, to ensure that process is fair and just for all. The Committee of Creditors is an important part of the insolvency and bankruptcy process in India. The Committee of Creditors is a group of creditors that are appointed to oversee the process of reviving distressed companies. They are responsible for approving a resolution plan for the distressed company, and they are also responsible for monitoring the implementation of the resolution plan. They are responsible for ensuring that the resolution plan is in the best interest of all stakeholders. The COC is best placed to make commercial decisions that are in the best interest of all stakeholders, including creditors, employees, and the company itself. The COC is expected to set the highest standard of conduct and performance in their decision-making processes, but no professional code of conduct for the Committee of Creditors have come into force yet. Even the Parliament has also stated that, I quote, there is an urgent need to have professional code of conduct for the Committee of Creditors, which will define and circumscribe their decision, as these will have larger implication for the efficacy of the code, unquote. It is important to note that judicial review in relation to decision made by the COC regarding the approval of resolution plans shall be limited. They include, but are not limited to, whether the resolution plan provides for payment of cost in a specified manner, whether the resolution plan provides for a payment of a specified minimum amount to dissenting financial creditors and operational creditors in a specified manner, and whether the resolution plan contravenes any provision of law. The court have upheld that, subject to limited judicial review on the grounds just stated above, court will defer to the commercial wisdom of the COC and not interfere with the decision of the COC. This has played a vital role in making the IBC a viable mechanism for insolvency resolution. However, if the professional code of conduct for COC or the code of conduct for the COC is included in the IBC or in the corporate insolvency resolution process regulations, it would provide an additional ground for judicial review. This is because the code of conduct would then be read as law, and any perceived non-compliance with the code of conduct would be a ground for assailing the approval of resolution plan on the basis that it contravenes provision of law. Therefore, the code of conduct will have to ensure that COC abide to the highest standard and conduct and performance in their decision-making process. At the same time, ensuring their autonomy and commercial wisdom is not interfered with. It is important to note that an insolvency professional is the backbone of an efficient insolvency resolution process. They are the ones who are responsible for guiding the process from the initial stage of assessment to the final stages of resolution. It is therefore crucial that we have a diverse and qualified pool of professionals to ensure that process is conducted in the best interest of all stakeholders. It is important that all stakeholders, including those from underrepresented groups, are heard, and those are affected by insolvency are given a fair and equal chance to participate in the process. The Insolvency and Bankruptcy Code is designed to promote transparency, fairness, and efficiency in the insolvency process. However, it is important that process is inclusive and that it takes into account the diverse needs and perspective of all stakeholders. This includes ensuring that rights and interests of small and medium-sized enterprises, as well as those of workers and other marginalized groups, are protected. This would not only ensure fairness, but also brings new perspective to the process. A diverse workforce given equal opportunities to succeed means that a business benefits from a wide talent pool. With the introduction of the Insolvency and Bankruptcy Code 2016, over the past 6 years, discussions around the quality, quantity, and qualifications of insolvency professionals have been at the center of the implementation conversation. However, certain issues have remained untouched. The points at the top of this list are: 1. The need for diversity, where a customized and equipment-based services and solutions can be offered by the curated pool of insolvency professionals. In order to achieve this, we need to ensure that there is a diverse pool of professionals with different backgrounds, skills, and experiences. This can be achieved by encouraging and promoting diversity in the recruitment and training process of insolvency professionals. Second, a consequential as well as independent issue being the number of women insolvency professionals. The representation of women in the insolvency professional is still low, and this needs to be addressed. We need to ensure that women are given equal opportunities in the insolvency profession and that there are no barriers to their entry and progression. This can be achieved by providing mentorship and support to women in the profession, as well as promoting and encouraging diversity in the recruitment and training process of insolvency professionals. I am a firm believer that diversity and representation in the insolvency professions are crucial for its success. By fostering a diverse workforce, we can ensure that business receive the best possible services and solutions, and that the insolvency profession remains at the forefront of innovation and progress. The sub-theme of ethics, redemption, and dignified exist. A study of failure and insolvency through the eyes of Hindu cinema is an interesting and valuable perspective that can provide valuable insight into the human aspect of those complex issues. The stories told on the big screen can offer valuable insights into social and cultural factors that influences the perception of insolvency. Hindi cinema has a rich tradition of storytelling that often explores the themes of failure, redemption, and dignified exit. These stories can help policymakers, practitioners, and other stakeholders in the field of insolvency and restructuring to understand the human experience of failure and insolvency, and to develop policies and practices that are more responsive to need of those affected. One of the key roles that courts have played in the court-supervised debt restructuring process under the IBC is to decide on a wide range of issues, such as the length of moratorium and the approval of restructuring plan. These decisions are crucial in ensuring the success of the debt restructuring process and the protecting of the rights of all stakeholders. The courts play a vital role in ensuring that the IBC process is fair, transparent, and efficient. The courts have to deal with variety of issues that arise during the debt restructuring process, such as the appointment of resolution professionals, the determination of the fair value of assets, approval of the plan. Courts also have the power to grant moratorium on debt repayment, which allows the debtor company to temporarily halt debt repayment and focus on restructuring the company. As we all know, balancing the interests of various stakeholders is not an easy task. The courts have had to strike a balance between providing certainty and predictability of creditors and investors, while also ensuring flexibility in the restructuring process to provide a fair outcome for the debtor. This balancing act is a complex one, and the courts have had to navigate a range of technical issues in order to reach a fair and just outcome. Looking to the future, it is important that we consider the development of a pre-insolvency framework as well as potential impact of cross-border insolvency. This can include an implementation of measures such as early warning systems and financial education program that can help to prevent insolvency from occurring in the first place, and also making necessary changes in laws and regulations to cater to cross-border insolvency. Many businesses today have interests stretching beyond their home jurisdiction. Firms are increasingly organizing their activities on a global scale, forming production chains including inputs that cross national boundaries. With the advent of sophisticated communications and information technology, cross-border trade is no longer the preserve of large multinational operations only. In cross-border insolvency, there are complexities which include the extent to which an insolvency administration has assets in a foreign country, priority of payments, recognition of claims, local creditors in a foreign administration, etc. These can be uncertainty risk of ultimately cost to business, therefore require careful deliberation in order to overcome these feelings. Finally, as we consider the future of insolvency, it is essential that we recognize the value of mediation as a means of resolving dispute and finding mutually beneficial solutions. Finally, I would like to mention the importance of mediation in insolvency. Mediation can provide a faster and more cost-effective way of resolving disputes, and we must explore ways to make this process more successful and effective. However, they are not used efficiently due to concern relating to enforceability, lack of incentive to employ it, and the concern relating to its capacity. If they can be enforced, then mediation can be successful in the insolvency situation in India. Ladies and gentlemen, it is my sincere hope that today's event will serve as a catalyst for further discussion and action in the field of insolvency and restructuring. By working together, we can ensure that India's footprint on the global insolvency horizon is one of strength, integrity, and fairness. I wish you all the best for the event and look forward to working with you, all of you, to shape the future of insolvency in India. Thank you, Jai Hind.